business before the court, draw near, give attention, and you will be heard. May God save the United States of America, state of Florida, and this honorable court. Please be seated.
Hey, good morning and welcome to another session of oral argument of the 5th District Court of Appeal. As Marshal Charlie has indicated, I am Judge Lambert, so they put me in the middle, so I guess I preside today. Let me introduce the panel for you. To my right and to your left is Judge Jamie Grosshans. To my left, to your right, we're happy to have an associate judge from Brevard County sitting with us. This is Circuit Judge Kelly McKibben. She's sitting for Judge Harris today. She's her second time sitting with us, so apparently she passed her audition the first time and she's back. So we're happy to have her here and pleased that she's helping us today.
Thank you.
Okay, we have 3 cases today on our docket. We'll hear them in the order in which they're situated on your docket. Each side will have 20 minutes total for their argument. Appellant, when you approach the podium and you introduce yourself, tell me how much time you'll want to have for rebuttal. We typically will set it at 5, but if you want a different amount of time, you'll just let me know and we'll set the clock accordingly. You'll see as you get into your rebuttal time the yellow light coming on. You can continue on with rebuttal, it's up to you, but that just gives you a heads up if you want to save some time. And again, it's 20 minutes total. We've recently had somebody who thought that meant that you got 20 minutes plus rebuttal time, and that really wouldn't be fair to the appellee. If anybody in the audience has any type of electronic device, phones, etc., that could go off, please either mute them or put them in silent mode so that they don't go off and interfere with counsel as they're arguing their case in front of us. Okay, with all the drum roll done, that being said, we will start with our first case, and again, that is RAMON MERCADO versus State of Florida, case 18-2307. So, counsel, whenever you're ready, come on up.
May it please the court. Good morning. My name is Nicholas Mattasini. I represent RAMON MERCADO in this direct appeal. I would like 5 minutes for rebuttal time, please.
All right, very well. Thank you, counsel.
Mr. MERCADO was convicted at a jury trial on multiple felony counts, as you all know, so this is a direct appeal from his criminal conviction. Mr. MERCADO argues 3 separate issues on this direct appeal. I would like to spend the majority of my time focusing on issue number 1, and we'll take any questions or comments on issues 2 and 3. Issue number 1 is that the trial court erred in allowing the victim to read a hearsay statement from a purported diary entry. Appellant argues that the statement should not have been admitted as a prior consistent statement because appellant never cross-examined the victim to show the jury an improper influence motive.
Now, counsel, 90.801 subsection 2 says if there is a direct or an implied charge that the person is fabricating, that you may then bring this type of evidence in, I believe. How would you argue that what the strategy employed by the defense was not implying that she was fabricating? I understand they chose not to cross-examine, but pretty much everything from the opening, every witness, closing, was definitely an implication that she had made the story up.
Well, I obviously have thought about and figured I would be asked that question. So what I can tell you is at least we know from the Wise case that opening statements in and of themselves are insufficient to allow a prior consistent statement in. So let's look at what actually happened during the testimony at trial. The state, in its answer brief, points to 2 specific instances where appellant was deemed to have opened the door for the introduction of this prior consistent statement. And I believe that the state argues that the questioning of Detective Bullock was one of those instances, the lead detective, in addition to the cross-examination of a law enforcement officer who visited her home. So the theme of the case was to sort of attack the witness interviews or attack the totality of the investigation itself. There were comments, there were questions that dealt with the collection of evidence and whether that was done satisfactory for this type of a case. And as your honors will remember, the defense in this case actually hired a DNA expert who testified at trial to challenge the weight of the DNA evidence that the state presented. So I think that there was a focus, of course, on the credibility of the victim, as there is in every sexual assault case where the victim's testimony is crucial. In many times, especially in this case, I think that it was. So there was an attempt to address the credibility of the victim alongside attacking the totality of law enforcement's investigation, in addition to some other pieces of the state's case, like the DNA evidence. So there was more than just an attack on her credibility. There was more than an implication that there was a fabrication. And I would point out to the court that I believe that the defense theory was that she fabricated the allegations from the outset, not that there was a recent fabrication just prior to trial. So I think there's some distinction there. I think the statute uses the two words together, recent fabrication.
Well, it also talks about motive. And it also the statute also talks about, is there a motive? And therefore, it's not just recent fabrication, motive. And it certainly seems like there's evidence that suggests her motive is that she became upset that she was lied to, if that's the right term, about Mr. Mercado not being her biological father, and that this is some kind of act of vengeance by making these alleged fabricated statements, although it seems like it was corroborated with the DNA that suggests that at least on one event there was improper sexual conduct with the child.
Yes, sir. In addition to that particular theme that she had found out that Mr. Mercado was not her biological father, there was also evidence and testimony at trial that the victim in this case wanted to move out of the family home to live with her boyfriend and did not have the financial means to do so. So that was another factor, I would argue, that the defense was allowed to raise at trial to give the jury a reason for the particular allegations in this case.
So based on your argument, is it your position that they have to be cross-examined, not just subject to cross-examination, in order for them to be impeached?
Reading the Wise case, I take that position. I understand that the statute, as pointed out by the state, does not specifically say it contemplates cross-examination of the witness in question where there's going to be a prior consistent statement. But when you read the language of the statute in conjunction with the cases analyzing it, it seems to require cross-examination of the witness whose consistent statement is going to be put forth.
Well, they could have written the statute that way, that said instead of being subject to it, says declarant testifies at the trial or hearing and is cross-examined concerning the statement, and the statement is, et cetera. I mean, and you know, we're big on the plain language stuff of the statute, as we're so frequently reminded.
It seems as though the statute would require cross-examination, although it does not specifically say that. And
no, it says subject to, which she certainly was subject to. If it was required, it would say, and she must be, the victim must be or the person must be cross-examined for the prior consistent statement to get in, and that seems to be problematic. But that doesn't seem to be the big part of your argument, or maybe it is. But
well, I mean, clearly she was not cross-examined, so we have that as a factor. But I think that the other issues in the case lend itself to the conclusion that the prior consistent statement should not have been admitted. It wasn't necessary. There wasn't a reason to put the prior consistent statement forward unless you wanted to bolster the testimony of the victim and add an additional aura of credibility to her testimony.
But wasn't the entire defense theory based on the fabrication, the fact that she was making up such allegations against Mr. Mercado? I mean, not just by the detectives' examination and cross-examination, but even further in the defense's case?
Yes, it was. I mean, the defense certainly had to be that the allegations were fabricated because he entered a not guilty plea and denied all the charges. So when you deny all the charges, and the charges are as they are in a sexual assault case, if you say you didn't do it, then obviously somebody's not telling the truth. And so I think that yes, there was an argument there. There was a position taken before the jury that the victim was not telling the truth, if we want to characterize that as a fabrication.
But in Wise, the state brought that out in their case in chief, though, didn't they? The consistent statement, which is,
Yes,
to
they
me,
did.
that's significantly, I mean, here, your argument, and I'm not saying you're not making a good argument, your argument would be, you know, obviously if the defense at this case at trial had put on no evidence, then if somehow that consistent statement had got in because of the opening statement that was made by counsel at the start of trial, then you would like that better for you, wouldn't you?
Yes, I mean, and I hope the court can understand that as a defense counsel, we just can't sit there and not do anything. We have to act in furtherance of our client's position, so there is going to be argument before the jury. There's going to be cross-examination of some witnesses, certainly to do our job.
Sure.
And in this particular case, there was clearly a tactical decision made not to cross-examine the victim, knowing, of course, that a prior consistent statement in the form of a diary entry could come in. I would argue, in addition, that I believe the court should have also conducted a 90.403 balancing test on the prejudicial effect of the diary entry. I think that's incumbent upon the court to always take that into consideration, especially in this type of case, given the powerful nature of the diary entry. I think that the prejudicial effect was certainly more probative or more apparent than any probative value that it may have. So that, I think, was also incumbent on the trial court and a factor in the court making a wrong
Getting
decision.
back to, I mean, I get the 90.403, but this is certainly significant evidence in rebuttal, so I'm not sure your side would have won on a 90.403 argument if it was made below. But anyway, getting back to, in the defense's case, I mean, the brother got up and testified saying, I don't believe my sister's allegations, basically, and talk about that she wanted to move out with her boyfriend and that he found a book and trust me, I'm lying, in her, you know, which certainly suggests the inference that why would you have a book, Trust Me, I'm Lying, unless the tie is that she's lying about all these things, and perhaps this book gives her tips on how to be a good liar.
You know, we can't change the name of the book that was found and presented to the jury.
You put it in, but you put that information in evidence because I assume you thought that was pertinent to your defense. And I know you weren't the trial lawyer, were you?
No, understood. Certainly, appellant made that decision to put that evidence before the jury to give them the ability to assess the relevant facts and circumstances. And
That the victim has a book that says, trust me, I'm lying, and that what's the significance of that? Well, the argument is she's lying about these allegations against Mr. Mercado, and therefore, when we fast forward a few hours in the trial, they put in rebuttals saying, you know, not for nothing, but back in January 2 of 2014, long ago, I write in the diary that we're starting off the new year where he's raping me. I think that's her exact words or something like that.
understood. So, I mean, you have...
It's a good rebuttal.
It is, but it was unnecessary in this case, and it was improper to allow it in because there was not a need to introduce the consistent statement.
Well, you're saying your defense is through the evidence, mother doesn't believe her, brother doesn't believe her, got a book that says, trust me, I'm lying, and so the state says, you know, not for nothing, I think we got something that says long ago she's been narrating this in her diary about this abuse from her adoptive father. And that's, I mean, isn't that the epitome of what a rebuttal case would be?
Well, then I think that may also where 90.403 comes into play, where you've got a balancing act.
Boy, it seemed like on balance you'd say, psh, the probative value, that's really high, and that outweighs anything that may be, obviously it's prejudicial. Anything the state generally puts in is prejudicial against a defendant. Otherwise, why would you actually put that in evidence at trial? But that being said, I give you that some evidence the state puts in is more prejudicial than other evidence, but this seems like to be the one that's right on the nose here in this case, saying, you know, you're basically saying I'm lying about this, and you're putting on my relatives I'm lying. You have a book from my room that I'm a liar. You know, way before this all happened, I got some statements that are consistent with what I'm saying right now. It sounds like it's kind of classic textbook what the statute's written for, isn't it? I know you don't like that, but.
Well, I mean, obviously I can't accept that position, but.
I appreciate that.
What I can tell the court is this is a unique case because it's a sexual assault case. There was some DNA evidence as to one particular count, but a large portion of the case was based primarily on the testimony of the victim. And you have, of course, a defendant who has entered a not guilty plea to all counts, which effectively, and the jury is instructed that the defendant has entered a not guilty plea to all of the charges. So that is essentially a statement from the defendant at the beginning of the trial saying the state's witnesses are not going to be telling the truth. And you know, of course, the jury is going to hear from opening statement what the evidence is going to consist of, and certainly the state focused primarily on what was going to be testified to by the victim. So when you have a not guilty plea and you actually take your case to trial, you are effectively saying the victim is not telling the truth. That is going to be the position in every sexual assault case where the primary evidence is the on-stand testimony of the victim at trial.
Let me ask you about one of your other arguments about you're unhappy, or you're asking that we find error with the state's motion limiting was granted to exclude the defendant's prior statements that basically I didn't do it. Are you just not liking that theory, that kind of hornbook law, or is it, what's your best argument as to why that isn't properly excluded as inadmissible hearsay?
So the best argument that I could come with comes from Justice Farmer's concurring opinion.
Judge Farmer, but.
Judge Farmer, in the Cotton case, and I really could not say it any better than him. The law allows, of course, an admission.
His concurring opinion
of guilt, but it doesn't allow an exculpatory statement. It just seems to be unfair. It just seems to be the type of evidence that ought to be presented before the jury where they can weigh it and assess it in conjunction with the jury instruction on defendants' out-of-court statements. It seems to be an issue of fundamental fairness. You would allow an inculpatory statement in under the same circumstances essentially as an exculpatory statement.
Well, I mean, so if he said to three neighbors, hey, you know, I just got arrested for this and I didn't do it, he couldn't call his neighbors in and say, hey, didn't Mr. Mercado tell me shortly after he was arrested he didn't do it? And there you go, that's good evidence for you to hear. And
He could not call.
right, he couldn't do that. You'd say that. You're just saying because of who he made the exculpatory statements to and the timing, that should be maybe an exception, or we should revisit this Hornbook view of it doesn't come in.
I think the argument asked for revisiting the Hornbook rule under the argument by Judge Farmer in this case.
And as to let's touch all bases here, as to your the argument about the failure to have the psychological evaluation done, do you agree with the observation made that by the trial judge that the Camejo case, the Supreme Court case that approved our earlier opinion, that those facts are seen more drastic in Camejo than here, and in that case they affirmed the denial of the psychological evaluation? Or alternatively, tell me why Camejo isn't dispositive here. And I'm Camejo. I don't know if I'm saying it right or not, but
I understand the court's questioning, and it's not an argument that I can really explain in any more detail than I put in my brief. I think that the circumstances here where you've got the mother testifying at the hearing about what she thinks are some issues going on with the daughter. You've got the nature.
The mother only made some generalized statements. She just said, yes, she needs help. I mean, that was her testimony. It wasn't anything in more in detail as to she'd been to this many psychologists. Isn't that accurate?
True. That in conjunction with the I guess the statements within the diary entries themselves. And so that, I believe, presented an extraordinary circumstance that required the trial court to allow the psychological examination. But I understand completely the facts and ruling in Camejo.
You're in your rebuttal. You can continue or you can reserve.
Yes, sir.
Okay. All right. Thank you, counsel. Okay, Mr. Carente.
Thank you, Your Honors. May it please the court, I'm Carmen Carente with the State of Florida Attorney General's Office. This court has really summarized the state's argument in the questions to opposing counsel We believe not only that this theory of defense was established on cross-examination, but clearly it was established in the defense case when they presented mother, brother, uncle, I think, from Puerto Rico. And what the defense did was they postulated this was a lie, but they further said this lie, the motive for this lie, began in June of 2015. Mother testified that that's when she was told she was adopted. So they explained the motive. That's the defense they were relying upon. And the state, I believe, had reason to rebut that by bringing forth evidence that she made that claim long before she knew. As to the psychological evaluation, the comments in the diary are not strong and compelling. The comments are she's questioning herself. She's spent 10 years being abused by somebody, and she's questioning reality. She's questioning many things, but it's not questioning. It doesn't show she's incompetent to testify. She testified about 4 hours, I think, at this trial. She testified at a previous trial. There was no basis from the previous trial's testimony they used as evidence to say she's not competent to testify. So they're basing it on credibility, and there wasn't any evidence that she was lying about her feelings. There wasn't any evidence to support the support the psychological evaluation. Lastly, the control call shouldn't have come in at all, but enough of it came in to give to the benefit of the defense. And there was no error, there was no abuse of discretion in any of these court rulings. And we would rely on our brief if there are no other questions.
Any questions? Okay. All right. Thank you.
Thank you so much.
Okay, counsel, you have 341 to, oops.
I just wanted to briefly address the harmless error analysis. I think in this particular case, the comments in the diary entry were highly emotional and sensitive in nature. And so that in-trial recitation as the last piece of evidence gave an unwarranted credence to the victim's testimony in this particular case. And so I don't believe that we can say that but for that testimony, the guilty verdicts wouldn't have been rendered. So I believe that the error in this particular case runs afoul of the harmless error test.
Fair enough. All right, counsel.
Thank you.
All right, thank you very much for your concise arguments. Well argued.